but in his most recent book on unwritten constitutionalism, he sort of takes this analogical method and really goes to incredible extremes with it. There's in any of these processes, any type of structural argument, the meaning of the words of the text has to operate as a constraint on what you can do with it. Structural arguments are better textual arguments to the extent that your structural argument comes from a provision in the text or a description of the relationship between other provisions of the text. There are other types of structural arguments, so-called ones, that I don't recognize as actually good, sound textual approach. And then there are some that are fairly debatable. So there'll be a range of the fact that one employs an originalist textualist methodology, including structural arguments, doesn't mean that there won't be some fair disputes as to how those apply in specific circumstances.
Keith, do you think modern new originalist theory has anything to say about that question?
I don't know whether it has anything to say about that question. My inclination is the same, though, thinking that I don't see a difficulty about structuralist arguments as such from an originalist perspective. I think they're perfectly reasonable as well as anything else. I'm not wedded to a clause-bound textualism and how I want to try to think about it. My concern about structural arguments in general is that they are often quite indeterminate, and sometimes the structural principles are coming from someplace else that is not very well connected to original meaning, right, broadly speaking, at all. But my concern about McCulloch, I have many concerns about McCulloch v. Maryland, but among them is that I think that particular principle, while a perfectly reasonable principle, is not clear it's a determinate outcome from a structure of federalism like the one we have embodied in that text and was adopted in that Constitution. So why should Marshall get to pick it rather than somebody else getting to pick which particular structural principles we're going to adhere to?
Bob? In many ways, Professor Irving's solution to this dilemma that we have is very, very tempting. But unfortunately, it's not available to Americans.
I knew that argument would arise.
It's not available to Americans because our materials of legal interpretation are rich in historical argument. We do not consider historical argument to be outside the province of lawyers and of law. Our political discourse, like our legal discourse, is saturated in historical argument, has been so since the founding. In that way, modern lawyers more closely resemble Edward Cook than they do a formalist judge. That's just not our legal tradition. The arguments for independence at the founding over constitutional structure have always been argued. Now, the difficulty for legal argument that as legal argument is closely tied to historical argument